Imagine a situation where one day you're unable to make decisions about your own life. Wouldn't it be reassuring to know there is a way you can plan ahead to ensure that your preferences are respected? Well, join us today as we journey into the world of LPAs. Hello and welcome back to Everything Estate Planning. I'm Jim, and today we're going to be exploring lasting powers of attorney, or LPAs for short. To make it even easier for you to find the information you need, we've added timestamps, allowing you to quickly navigate to any specific section you want to watch. In regards to LPAs, there are some specific terminologies that you will hear and you will need to be aware of. These are, in the main, the Court of Protection. Now, this is the governing body which oversees the Office of the Public Guardian, which is the OPG, who in turn are responsible for registering LPAs, or lasting powers of attorney. Now, the OPG, the Office of the Public Guardian, is who you must send your completed LPA forms to for registration. You're also going to hear the word donor. Now, the donor refers to the person who is creating the LPA. That's you. And you'll also hear, finally, attorney and donee. Now, these terms refer to a person that you are nominating to take on the responsibility of your affairs, and they are one in the same. Let's go over what we're going to cover today. By the end of this video, you will, 1, understand what a lasting power of attorney, or LPA, is and the different types that are available. 2, understand why LPAs are important and how they can benefit you and your loved ones. 3, know the steps to set up an LPA, including choosing your attorneys and registering the LPA. 4, be aware of the responsibilities and the limitations of attorneys. 5, recognize the safeguards in place to protect you and ensure your attorneys act in your best interests. 6, learn how to make changes or revoke an LPA if your circumstances change. With these learning outcomes in mind, and without further ado, let's get started. So what is a lasting power of attorney? There are 2 types of LPA in England and Wales: the Health and Welfare LPA and the Property and Financial Affairs LPA. Let's break these down one by one. A Health and Welfare LPA, or lasting power of attorney, allows a trusted person of your choosing, known as an attorney, to make decisions about your personal health and welfare. Notably, this type of LPA can only become active once you have lost capacity. Here are some examples of things your chosen attorney can make decisions about. Your daily routine, such as what you eat and what you wear. Medical care, including treatments and procedures. Moving into a care home or other accommodation. Decisions about life-sustaining treatment. In order to highlight the importance of creating a Health and Welfare LPA, let's explore a couple of scenarios. The first involves Josie, a 68-year-old woman who set up an LPA, allowing her daughter, Chloe, to make decisions aligned with Josie's values if she loses capacity. The second depicts Laura, a 71-year-old woman who did not establish an LPA before being diagnosed with dementia, leaving her family struggling to make crucial decisions without legal authority. Josie has always been proactive about her future, understanding the unpredictability of life. She decided to set up a Health and Welfare LPA years before any health issues arose. Now, this foresight ensures that her personal health and welfare decisions will be made by someone she trusts, if she ever loses the capacity to make them herself. Josie appointed her daughter, Chloe, as her attorney, confident in Chloe's understanding of her values, preferences, and medical history. Josie expressed specific wishes about her medical care, including staying at home if possible and avoiding life-sustaining treatment if severely incapacitated. The Health and Welfare LPA becomes active once Josie loses capacity, legally empowering Chloe to make decisions on Josie's behalf. Decisions involving Chloe arranges for in-home care, respecting Josie's wishes to stay at home. Now, when Josie develops a severe infection, Chloe decides against aggressive treatment, aligning with Josie's preferences. Chloe manages Josie's daily care, ensuring her mother's preferences are honoured. The LPA allows Chloe to make informed decisions that align with Josie's wishes, maintaining her mother's comfort and dignity throughout her illness. Now, let's take a look at the second scenario. Laura lives independently, but is diagnosed with early stage dementia. Now, as the condition worsens, she loses the ability to make informed decisions about her health and welfare. Laura did not set up a health and welfare lasting power of attorney, or LPA, before her diagnosis, leaving no designated person to make decisions on her behalf. Laura's family, including her daughter Emily, must make decisions for her without clear legal authority or guidance. Some decision-making challenges they faced include: the family is divided on whether Laura should stay at home with hired help or move to a care facility, leading to disagreements. When Laura develops a severe infection, the family struggle to decide on her treatment preferences, causing delays as doctors need a consensus. Inconsistent day-to-day care from different family members affects the quality of Laura's care. Due to ongoing disagreements and the lack of an LPA, the family applies to the Court of Protection to appoint a deputy. Now, this process is time-consuming, costly, and emotionally draining. The absence of a pre-established LPA leads to significant stress for Laura and her family. Delays in decision-making impact Laura's well-being, and the family faces avoidable legal and financial burdens. Now, these examples illustrate the challenges and complications that can arise when an LPA is not set up before you lose the capacity to make your own health and welfare decisions. It highlights the importance of proactive planning to ensure smooth and respectful management of your care. A Property and Financial Affairs LPA allows your chosen attorney to make decisions about your money and property. Unlike the Health and Welfare LPA, this type of LPA can be used as soon as it is registered with your permission, even if you're still capable of making decisions. Here are some responsibilities your attorneys might take on: managing your bank account or building society accounts, paying your bills and handling your finances, collecting benefits or pensions on your behalf, managing, buying or selling property. Again, we'll examine two scenarios highlighting the importance of setting up a Property and Financial Affairs LPA. The first scenario is about Steve, a meticulous 72-year-old man who wisely establishes an LPA to ensure his financial matters are managed by his trusted son, David, in case of incapacitation. Now, the second scenario depicts Roger, who is also 72, who suffers a severe stroke without an LPA in place, leaving his family to navigate complex legal and financial challenges without the necessary authority to manage his affairs. Steve has always been meticulous about his finances, understanding the importance of planning ahead. He decides to set up a Property and Financial Affairs LPA to ensure that his financial matters will be managed by someone he trusts if he ever becomes unable to do so himself. Steve appoints his son, David, a financial advisor, as his attorney, ensuring competent management of his financial affairs. Steve specifies conservative investment management, timely bill payments, and proper property maintenance. Years later, Steve suffers a severe stroke, rendering him unable to manage his finances. Now, with the LPA activated, David manages Steve's finances in the following ways. David efficiently handles income and expenses and timely bill payments. David adjusts Steve's portfolio to align with a conservative strategy. David manages Steve's rental property, including rent collection, maintenance, and tenant relations. David sells Steve's unused holiday home, investing the proceeds for long-term care. David ensures funds are available for Steve's medical, home care and personal expenses. The LPA enables David to seamlessly manage Steve's finances, ensuring financial obligations are met and assets are managed according to Steve's wishes. That is, proactive planning maintains Steve's financial stability and ensures his comfort and care during incapacitation. Now, let's take a look at the second scenario. Roger suffers a severe stroke, leaving him incapacitated and unable to manage his finances. Now, we all know he never set up a Property and Financial Affairs LPA, and without an LPA, no one is legally authorised to handle Roger's financial responsibilities. Roger's family, including his son Brian, struggle to manage his finances without legal authority or guidance, and some immediate challenges evolve. These are: Brian cannot access Roger's bank accounts to pay bills or manage expenses. Roger's investment portfolio remains unmanaged, as Brian cannot make necessary adjustments. Issues arise with Roger's rental property due to the lack of authorised management. Bills pile up, leading to late fees and potential service interruptions. The family decide to sell Roger's holiday home to cover care, but Brian lacks the legal authority to initiate the sale. The family must apply to the Court of Protection to appoint Brian as Roger's deputy, a process that is lengthy, costly and requires significant paperwork. While awaiting the court's decision, the following issues arise. The family face financial strain, covering Roger's expenses out of their own pockets. Essential financial decisions and property management tasks are delayed, causing financial losses and property neglect. The absence of a pre-established LPA results in significant stress and financial complications for Roger and his family. Delays in accessing and managing Roger's finances impact his financial stability and the family's ability to ensure his well-being. Unfortunately, deputising Brian through the courts is a long, drawn-out process, and sadly, Roger passes away before this process is completed, a case which is all too common in this particular scenario. Now, these examples highlight the challenges and complications that can arise when a Property and Financial Affairs LPA is not set up before you lose the capacity to manage your own financial matters. It emphasises the importance of proactive planning to avoid legal and financial difficulties. There is a real-world example that further emphasises the importance of LPAs and planning for the future. Some of you may remember the case of the British celebrity Kate Garraway and her husband, Derek Draper. Well, after Derek fell seriously ill with COVID-19 and lost capacity, Kate was left to care for her husband without the vital tool that is an LPA. Now, if you'd like to read more about that, we'll leave a link to an article on our website in the description. So, to summarise, here are some key reasons why LPAs are so important. It allows you to choose trusted individuals to make decisions on your behalf. It ensures your wishes are respected, preventing family disputes. It grants your attorney legal power, avoiding court-appointed deputies. It enables prompt action for medical and financial needs, protects your financial interests and ensures bills are paid. It manages medical treatment and living arrangements in your best interest. Recognised document for interactions with banks and healthcare providers. Can be revoked if circumstances change, and specifies when it takes effect. Overall, an LPA is a proactive measure to ensure that your affairs are managed according to your wishes and by individuals you trust, providing security and peace of mind for the future. So we've established that setting up an LPA is probably a good idea. But what are some considerations we need to make before we go ahead and make one? First and foremost, selecting the right person to act as an attorney is a crucial decision in setting up an LPA. Here are some factors to consider. Your attorney should be someone you trust completely, as this person will have significant control over your affairs. Choose someone who is responsible and reliable. They should be able to handle financial matters if you are setting up a Property and Financial Affairs LPA. The attorney should understand your values and wishes, especially for a Health and Welfare LPA. Ensure that the person you choose is actually willing to take on this responsibility. it can be a very demanding role, so it's important that they are fully on board. An important mention is that you can appoint more than one attorney and specify whether they should make decisions jointly. For example, they must agree on all decisions together, or jointly and severally, i.e. they can make decisions independently of each other. So let's get into some practical tips for setting up an LPA, which involves several steps. So here's a step-by-step guide to help you through that particular process. We've already covered this step. Remember, you can choose more than one attorney and specify how they should make decisions. Consider seeking assistance from a legal professional, such as a solicitor or an estate planning specialist. This can be highly beneficial for several reasons. Professionals have a thorough understanding of the legal requirements and can provide expert guidance on completing the forms accurately. Errors in these forms can lead to delays or rejection of the LPA by the Office of the Public Guardian. A professional can help avoid these mistakes. They can offer advice based on your specific situation and preferences, ensuring that your LPA reflects your wishes accurately. Having a professional oversee the process provides peace of mind that your LPA will be legally sound and effective when needed. The LPA forms can be obtained from the Office of the Public Guardian's website. You just need to Google OPG or Office of the Public Guardian. There are two separate forms, one for health and welfare and another for property and financial affairs. You and your attorneys need to sign the forms. Additionally, a certificate provider must sign to confirm that you understand the LPA and have not been pressurized into making it. The certificate provider can be someone you've known for at least 2 years, or a professional such as a doctor or legal professional. Send the completed forms to the Office of the Public Guardian along with the registration fee. As of the current fee structure, the cost is £82 per LPA. Now this is obviously subject to change over time, so please double check first. It is worth noting that if you receive certain benefits or have a low income, you might be eligible for a reduction or exemption from the fee. You need to notify certain people, such as your family members or close friends, when you apply to register your LPA. This step ensures transparency and gives them an opportunity to raise any particular concerns. So we've highlighted the importance of selecting your attorney carefully, but you may still be wondering what's to stop an attorney from taking advantage of the power of an LPA. This is a very reasonable concern and one that we will tackle in the upcoming section. Crucially, the LPA system has built-in safeguards to protect you from abuse and ensure your attorneys act in your best interests. Now, these include a certificate provider must confirm that you understand the LPA and are not being coerced into creating it. The OPG, or the Office of the Public Guardian, monitors attorneys and can investigate any concerns or complaints. If there are serious issues, the Court of Protection can intervene, revoke an LPA, or make decisions on your behalf. Attorneys must follow the principles of the Mental Capacity Act 2005, and they must act in your best interests and consider your wishes and feelings as much as possible. At this stage, it is important to mention the predecessor to LPAs. These are known as Enduring Powers of Attorney, or EPAs. And while EPAs are still valid if they were created before October the 1st, 2007, we highly recommend creating an LPA instead. Where EPAs are rigid and open to misuse due to a lack of safeguards, LPAs provide comprehensive coverage with enhanced safeguards, greater protection and flexibility. As we all know, life is fluid and our circumstances are always subject to change. So what happens if you need to amend or revoke your LPA? You cannot amend an existing LPA. If you need to make changes, you must create a new LPA and revoke the old one. To revoke an LPA, you must have the mental capacity to do so. You need to inform your attorneys and the Office of the Public Guardian in writing. If your chosen attorney can no longer fulfill their role, you will need to create a new LPA to appoint a new attorney. In summary, Lasting powers of attorney are a vital part of estate planning. They ensure your wishes are followed and can make a difficult time a bit easier. Here are some final recommendations. Don't wait until it's too late. Set up your LPA while you have the capacity to make informed decisions. Consider getting professional advice to ensure your LPAs are correctly set up and tailored to your needs. Regularly review your LPAs to ensure they still reflect your wishes and circumstances. If you have any questions or need any assistance with setting up an LPA, please don't hesitate to contact us at Elm Legal Services. We are here to help. Thanks for joining us today. As always, if you have any questions or want to share your thoughts, please drop them in the comments below. We love hearing from you and want to continue providing useful information to a broader audience. If you found this video helpful, give that like button a friendly handshake and hit the subscribe button to stay updated on all of our latest content. Join us in the next episode where we'll learn about trusts and how they can help us protect our assets. Remember, a little planning today can make a big difference tomorrow. So until next time, stay safe, stay informed, and stay tuned.